2, 1.
This Honorable Court of Appeals of Tennessee is now in session.
Thank you, Ms. Lindsay. And on behalf of Judge Stafford and Judge Armstrong, we welcome Mr. Green and Mr. Hurst to this oral argument, which we are live streaming for the public viewing, and it is being recorded and will be posted on the court website for further viewing at a later date. We will conduct the hearing in the same fashion as if we were all in the courtroom. Each of you has 15 minutes for your argument, and the appellant has reserved some of that time for rebuttal. Unless there are any announcements, I will ask Ms. Lindsay to call the case.
J. Pemberton Guerry versus James Christopher Jenkins et al.
Thank you. And Mr. Hurst, you have the floor.
Good morning, and may it please the court. My name is James Hurst. I'm here on behalf of Mr. Jenkins and Ms. Jenkins in this appeal. The matter before the court is a simple matter. It's a simple issue of contract interpretation. It's properly before the court as a matter for de novo review with no presumption of correctness in order to the trial court's interpretation of the contract. In this case, the promissory note was presented to the trial court for interpretation. No amount of terrible lawyering can relieve the trial court's duty to properly interpret that contract. When the trial court misinterprets a promissory note or contract, the Court of Appeals has the jurisdiction to review and correct the misinterpretation and apply justice to the case. Appellee would like for this appeal to be about many other issues, including application of request for admissions. However, the only issue before this court is the interpretation of the promissory note. And by way of background, which you have in both of our briefs, the trial court granted Appellee's motion for a partial summary judgment relative to a promissory note in the principal amount of $14,194.43. Specifically, the court ruled that, and I'm quoting, as a result of the appellant's breach of the promissory note, Appellee has incurred damages in the amount of the principal and interest due under the promissory note. The court goes on to state in its ruling, as provided by the terms of the promissory note, Mr. Guerry is also entitled to a judgment against appellant for all costs of collection, including but not limited to reasonable attorney fees, court costs, expenses incurred by appellee in connection with his effort to enforce his rights under the promissory note. And nowhere in this ruling does the trial court incorporate any other claims or address any other claims by the appellee. The promissory note clearly states in its caption that it is a promissory note, and it states that the principal amount of the promissory note is $14,194.43. There were several claims before the trial court that, if proven, could have provided the groundwork for a much greater award to the appellee. Indeed, there were other agreements between the parties that would be the basis for additional claims between the parties and potential awards between the parties or against one or the other party. But the only claim for which the trial court granted a summary judgment and for which that judgment was sought relates to a negotiable instrument, the promissory note, in the amount of $14,194.43.
Well, let me ask you, Mr. Hurst, what do we do with the sentence in the promissory note that reads, "This note shall not be determinative of any future obligations regarding the maintenance of equal shares of the capital and debt of FTS if either party subsequently contributes additional capital or pays additional debt beyond what Mr. Jenkins and Mr. Guerry have presently agreed.
Well,
What
Your
do we
Honor,
do with that?
that is the question here before the court. And the answer to that is that there are other agreements, as I just mentioned, between the parties. And there are actually other claims in the complaint for contribution related to other documents, bank notes that they have entered that could lead and allow for Mr. Guerry to pursue and recover additional claims against Mr. Jenkins. So that statement is a way of saying that by way of a $14,000 promissory note executed by the parties are not stopped from pursuing other claims against the parties that are outside of this note. And illustrative on that point is that the four corners of this note, and that this note is a $14,194 promissory note, can be found in section 5B, where it states that the borrower agrees that the lender shall be entitled to all rights of a holder in due course of a negotiable instrument. As we know, a negotiable instrument is an unconditional promise under Tennessee law, is an unconditional promise or order to pay a fixed amount of money. Now, if we were to treat this document as anything other than if we were to treat this document as a negotiable instrument, as it says it shall be, then you can't bring in other claims, principal claims, in excess of the $14,194.43.
Well, if it does not qualify under the UCC as a, quote, negotiable instrument, close quote, cannot it still be enforceable between the parties?
Yeah, well, of course, it can be enforceable between the parties. The point that I'm making, Your Honor, is that the parties express their intent that this is a promissory note, a negotiable instrument for the principal amount of $14,194.43 by agreeing that the holder shall have the rights as a holder of a negotiable instrument, a holder in due course of a negotiable instrument. And the rights that gives the holder are different than a party to a contract. If you're a holder, as you know, Your Honor, of a negotiable instrument, you have the authority, the power under that negotiable instrument to go sell it to any party who's willing to buy it. Other contracts are not necessarily freely assignable like that. So the right granted by this negotiable promissory note to Mr. Guerry was that if he wants to liquidate and receive value for that note immediately, he can go to a third party and sell it for the face value. With other contracts, he would not have that right.
So let me make sure I'm understanding what you're saying. You're saying, I believe, that the only thing that the appellee was entitled to collect would be the promissory note itself. Is that correct?
Yes, Your Honor.
Okay. Did the appellee request to collect under the contract and the other indebtedness that flows from that contract?
Yes, Your Honor. Those were claims in the complaint between the parties. And
why was the court not allowed to go ahead and adjudicate those claims at summary judgment?
Because the only matter presented by the appellee were claims presented in cause 1 of the plaintiff's complaint, which are related specifically to this promissory note. It was a limited motion for summary judgment, or motion for partial motion for summary judgment. Sorry, I got tongue tied. And that the claims pursued related only to the promissory note in that motion for partial summary judgment.
Okay.
Anything further, Mr. Hurst?
Well, Your Honor, I believe that in replying to your question, I have addressed all that I intended to address. Thank you, Your Honor.
All right, thank you, Mr. Hurst. We'll hear from you on rebuttal. Mr. Green.
Thank you, and may it please the court. Mr. Hurst made a statement that the appellee, my client, Mr. Guerry, wants to make this case about several other things. I want to make this case about what this case is about. And the courts of this state have made clear that a party against whom a motion for summary judgment is filed must take that motion seriously. They must respond with opposing evidence. As this court said in the Mark 7 transportation case that we cite in our brief, silence does not suffice. The penalty for remaining silent is severe. As this court said in the Holland versus City of Memphis case, the failure to respond to a motion for summary judgment generally will prove fatal if in the trial court and on appeal. After filing his answer in this case, Mr. Jenkins went silent. He did not sign and serve verified interrogatory responses. But more importantly, he did not respond to requests for admission. He never responded to the motion for summary judgment. He did not object to or respond to the statement of undisputed material fact. Under longstanding precedent, the facts presented in those documents, the existence of the promissory note as a contract, Mr. Jenkins' breach of that contract, and the amount of the debt Mr. Jenkins owed to my client, Mr. Guerry, became dispositive factual admissions. And as the Supreme Court said in Barbie, that concludes the matter. The trial court correctly granted summary judgment for Mr. Guerry on that basis and correctly awarded damages in the amount of the debt plus interest according to the note. The issue that the appellant presents on appeal is about the interpretation of the promissory note, but he never raised that issue below. He remained silent on that issue because he didn't respond to the motion for summary judgment. He didn't raise this issue at the summary judgment hearing. He did not raise this issue in the damages hearing. And even though it would have been futile, he didn't raise this issue in a post-judgment motion.
Let me ask you a question, Mr. Green.
Yes, Your Honor.
Did you set out with specificity what you were attempting to collect? In other words, it was the promissory note. The promissory note then gave rise to these other damages as contract.
Yes, Your Honor. From the date of the complaint, we have been clear. Our interpretation of the promissory note is creates through the parties' conduct and the way that they attributed their contributions and assumption of responsibility for the debt. The amount of the debt at the time the promissory note was entered was $764,000 and change. That was stated in the complaint. It was stated in the motion for summary judgment. It was presented at the summary judgment hearing, and Mr. Guerry testified about it, and it was presented at the damages hearing. At no time did Mr. Jenkins contest that amount or say that the promissory note should be interpreted in a way that the only debt that he owes is $14,000. That's never been raised until the appellant's brief was filed in this case. So our position is that argument has been waived. The trial court granted, and it's very clear what the trial court did in this case. The trial court granted summary judgment because Mr. Jenkins remained silent, because Mr. Jenkins didn't respond to the RFAs. We have established facts. Because Mr. Jenkins didn't respond to the motion for summary judgment or the statement of undisputed material fact, which includes contract, breach, and amount of damages in the amount we say, the 764 plus interest. The court granted summary judgment based on those factual admissions. Mr. Jenkins never attempted to create a disputed issue of material fact. And there are numerous cases from the Court of Appeals and the Tennessee Supreme Court stating that trial courts have discretion to do exactly what Judge Hedrick did in the circuit court. That is the basis of the summary judgment. The court did not get down this road of the contract interpretation point that Mr. Hurst is arguing today because he never raised it. The court found that there were undisputed facts presented through the request for admissions and the statement of undisputed material fact and entered summary judgment on that basis, which it has discretion to do. Mr. Jenkins does not challenge in this court the trial court's decision to accept those admissions and apply them and grant summary judgment. Therefore, he has no basis on which to challenge summary judgment in this court because silence does not suffice.
Mr. Green, on what basis does your client have the right to recover interest and attorney's fees under the contributions and debt that either party subsequently contributes or pays? Because the promissory note says this note shall not be determinative of those things. But does the note or any other written agreement say on what basis your client is entitled to recover those sums and whether interest is available and whether attorney's fees are available?
The attorney's fees provision is in paragraph 3 of the note, which is in the record at page 63. He's entitled to attorney's fees to collect, to enforce his rights under the note.
Under the note.
And let me be clear here. Your Honor, Judge Clement, you cited to a particular sentence in the note, which I agree with the way you stated. It's not determinative of future obligations, but that's one sentence at the end of a long paragraph that says that the purpose of the note, the intent of the note, is to make sure these contributions are equal. And the way the parties agreed to do that is for the borrower, Mr. Jenkins, to assume responsibility for the payment of money, for the repayment of money. I think that's important. The repayment of money that Mr. Guerry pays, or the repayment of indebtedness that Mr. Guerry incurs on behalf of FTS. That whole paragraph is the basis on which we brought this claim for breach of contract. And the amount of indebtedness, the parties' obligations are set out in Exhibit A to the promissory note, which is mentioned in that paragraph and attached to the promissory note. And in that Exhibit A, it states that the total commitment, the obligation that Mr. Jenkins had is the new debt under the promissory note and the SunTrust line of credit, the $750,000. Mr. Guerry had to pay most of that line of credit. Mr. Jenkins, and this is this is in the damages hearing transcript, Mr. Jenkins made 8 payments under the toward the SunTrust debt, an amount in excess of $14,000. So the notion that this is a $14,000 debt and nothing more is not supported by the record. So
I agree with you that your client's claim is not limited to the $14,000 figure. What I'm trying to better understand is upon what verbiage, what language
interest
in a piece of paper is your client relying upon to recover the other $700,000?
Right. The others, well, I think this started, and I'm giving you a long answer to a simple question about interest and attorney's fees. And I've addressed the attorney's fees. The interest provisions are twofold. There was interest running on the SunTrust debt. And so when Mr. Guerry eventually retired that debt, he paid approximately $899,000 to retire that $750,000 debt. So that's part of the interest. Then under paragraph 2 of the promissory note, there is an after maturity interest provision. And when the total debt came due and Mr. Jenkins was supposed to pay Mr. Guerry what he owed, which was by October 1st, 2013, and Mr. Jenkins did not do that, did not pay, after maturity interest began to run. And so when we went through the damages calculation in the trial court, that was all set out, and it's in the exhibit volume where Mr. Guerry testified about the amount he paid to retire the SunTrust note, the interest that ran on the $14,000 here, then the after maturity interest for the debt after Mr. Jenkins failed to pay, and then the attorney's fees to which Mr. Jenkins stipulated as to the amount and the reasonableness. That all adds up to, over a long period of time, because this note matured in 2013, to the amount of the judgment, $1,699,000 and change.
Let me split a couple of more hairs. The only members of the LLC were your client and Mrs. Jenkins, not Mr. Jenkins. But
I believe that is correct. Certainly at one point that was correct.
Okay. Thus, if that's still correct, then your client is not relying upon any of the LLC documentation to recover these funds. Your client is relying on a document that is titled promissory note.
That's what our claim is for breach of this promissory note.
So that's the only piece of paper we need to read to determine the rights of the parties.
That's right. But again, Your Honor, I mean, I think to get to the determination of the rights of the parties, we have to walk past the basis for the trial court's ruling, which is that these matters were disposed of when Mr. Jenkins failed to respond to the request for admission and failed to respond to the motion for summary judgment. You know, and I would cite the cardiac anesthesia case, respectfully, which Judge Stafford, you wrote, which mentioned in an instance where there was no response to a statement of undisputed fact. The court said there are no disputed facts because there was no response. And I'll cite to the court in the time I have remaining, there are at least 3 cases that we have cited in our brief in which the request for admission or the statement of undisputed material fact stated the amount of a debt. There was no response to the statement of undisputed material facts, and the court entered summary judgment, and that summary judgment was affirmed on the amount of the debt stated in the motion or in the statement of undisputed material fact. It's the Mark 7 transportation case, which I mentioned, There is American Express versus Fitzgibbons and SunTrust versus Ritter, all three of which we cite. And so in the short time I have remaining, I want to reiterate that silence in the face of a motion for summary judgment does not suffice. And that's what the court relied on in granting summary judgment in this case. We also believe, certainly, if the court takes up the contract interpretation question, which was not raised below, was not presented below, there was no discovery on it below, and the court didn't conduct fact finding on it below. I don't think the court needs to get to that question to affirm the summary judgment, but if it does, the promissory note is clear that Mr. Guerry is entitled to the judgment he received, and we ask that the court affirm the summary judgment.
Thank you, Mr. Green. We'll now hear from Mr. Hurst on rebuttal, and be sure to unmute. While you're doing that, Mr. Hurst, summary judgment, we look at whether there are material facts in dispute and whether there's a mistake of law. I don't see any way we can find any material facts in dispute, since your client did not dispute the plaintiff, the movement's statement of facts. Do you agree?
Well, if I may address that issue, and it's stated in the briefs, we are not arguing against the effect of the failure to respond to the request for admissions. It's a matter of law that we're addressing on appeal. And as I stated in the opening, there's nothing that terrible lawyering can do to abridge the duty of a trial court to read a contract and apply it correctly. And counsel stated that the amount of damages was raised at the summary judgment hearing, which is not entirely accurate. It was raised at the damages hearing, the damages portion. At the final, the argument at the summary judgment level did include statements by the appellant that the note was for $14,000, $194. As a matter of fact, Appellee pointed that out in Appellee's brief. If you look at the request for admissions, nothing in the request for admissions sets forth the amount of damages. Now, what I don't want us to lose sight of is that we have a partial summary judgment motion. And so the judgment granted relative to that partial summary judgment motion has to focus on that partial summary judgment. You can't just bring stuff in off the street and add it to that. The partial summary judgment motion relates to this contract, this negotiable instrument, not to anything else. Now, if you look at the record, there are other agreements between the parties. Like I stated, the SunTrust note, and like counsel stated, there's also another agreement between the parties referenced that is named, sorry, Your Honor, acknowledgement of indebtedness and indemnification agreement. There are other agreements between the parties that would get plaintiff or appellee to the amount of relief that he's seeking, potentially, including claims for contribution, which are in the contract, including claims for breach of other contracts. But the promissory note before the court does not incorporate those claims. It does reference those claims by saying this is how we calculated the $14,194.43. But nothing in this paragraph states that borrower shall pay holder or lender anything more than the principal amount of $14,194.43 plus interest, penalties, and attorney fees. Nothing in the note says that. That paragraph does set forth and explain how we got to that number, which is an odd number, $14,194. $194.43. But nothing in this negotiable instrument incorporates other obligations. If it intended to incorporate other obligations, it would have said, borrower shall pay any other amounts due pursuant to these obligations referenced in this agreement. There's no shall pay. There is a shall pay with regard to the $14,194.43. The fact that the summary judgment was entered relative to the summary judgment motion, the partial summary judgment motion, is not disputed here on appeal. It's the interpretation of the negotiable instrument upon which that judgment was entered. Thank you.
All right. Anything further, Mr. Hurst?
That's all. Thank you, Judge.
Thank you, Mr. Hurst and Mr. Green, for your arguments. We will take this case under advisement. Ms. Lindsay?
This Honorable Court of Appeals is now in recess until 1:30 Eastern Time.
Thank you, Ms. Lindsay, and counsel, you may exit the meeting.
Thank you.
Thank you.